Hi, my name's David Haig. On December 18th, I was tased 10 times in Anchorage court for trying to present physical evidence proving my case, along with proving serious criminal conduct by government officials. Since I was prevented from presenting the evidence in court, I'll try to present it now. Prior to my trial, my first attorney, Brent Cole, told me Assistant Attorney General Scot had given me immunity, and that this required me to give Leaders and Trooper Gibbons a statement. When Leaders continued to prosecute me in violation of my immunity and quoted my statement to do so, our business attorney Dale DeLifka stated Brent Cole had sold me out and I must hire attorney Arthur Robinson, which we did. We fired Cole and hired Robinson. I will now show the physical evidence that Scot Leaders illegally prosecuted me and then committed perjury to the Alaska Bar Association to cover up. And the Alaska Bar Association didn't do anything about it. Okay, you can come over here. Where you can read it. Okay, this is State of Alaska Plaintiff versus David Haig, defendant. Case number is received April 26, 2005 by Robinson Associates Lawyers. It's a second amended information. In this information, it says David S. Haig was interviewed in Anchorage on 6/11/04. And it's also Tony Zellers was interviewed later. Summary of the statements of the two men as follows. In this charging document, it quotes my statement. It says on 3/6/04, Haig called, satellite phone, reported to McGrath. Goes through some other stuff. Anyway, there's some more statements here where they're quoting what I stated. And anyway, here it's signed by Scot H. Leaders, Assistant Attorney General, Alaska Bar Association number 9711067. On 5/6/05, Chuck Robinson filed in the District Court for the State of Alaska, 4th Judicial District at McGrath, State of Alaska versus David Haig, case 4MC SO4-24CR. In this motion, Mr. Robinson states there's another piece of evidence that needs to be addressed. At the time the first amended information was filed, there was no plea between defendant and the state. As is revealed by Mr. Haig's affidavit, there were plea negotiations that took place between the parties before the filing of the information, but the parties failed to carry out any plea agreement. During the plea negotiations, defendant made statements to the police that were recited by the prosecutor in a statement in support of the amended information. The significance of this fact is that the defendant's statements made during plea negotiations that do not end in a plea agreement are not usable in any judicial proceeding, including the filing of an information. See Evidence Rule 410. Yet the prosecutor used these statements in support of all three informations in violation of the evidence rule. Dated Soldotna, Alaska, 6th day of May 2005, Robinson Associates, signed by Arthur Robinson. And this is important here. Certificate of service. I hereby certify that a copy of the foregoing was served on DA Scot Leaders by fax and by courier on the 6th day of May 2005 by Laura R. Hansen for Arthur Robinson. So it was certified as sent to Scot Leaders in two different manners, or two different ways. It was also sent to Mr. Leaders at a district attorney conference at the Alaska Ski Resort. And this is certified, document is confirmed. Here's the confirmation. Total pages scanned 3, total pages confirmed 3. Has District Attorney Scot Leaders, and it has the Alaska's fax number. It says, please deliver to Scot Leaders attending the District Attorney Conference and guest at your hotel ASAP. So it was also faxed to Scot Leaders at the Alaska Hotel. Here is what went to him. Here's the original. District Attorney Scot Leaders, telecopier number 907-754-2200. Remarks, please deliver to Scot leaders attending the District Attorney Conference and guest at your hotel ASAP. Remember, 3 pages. Here's the other 2 pages. Here's page 2. Affidavit of David Haig, State of Alaska, 3rd Judicial District. David Haig, being first duly sworn, states, I'm defendant in the above captioned case. I have personal knowledge of the matter stated in this affidavit. From June 2004 to November 2004, I engaged in plea negotiations with the state's prosecutor, Mr. Leaders, concerning the filing of the state game charges against me. The plea negotiations came to an end on November 8, 2004. The prosecutor, at the last minute, backed out of an agreement I thought was reached. The negotiations ended without a plea agreement between myself and the state. The prosecutor thereafter filed an amended information. I appeared in court on November 9, 2004 for arraignment on the amended information that charges me with numerous violations of state game laws. I pleaded not guilty to all the charges. The court scheduled a jury trial for me to stand trial on the charges. During the plea negotiations, I gave statements to the police regarding accusations of game violations that are in the statements in support of all 3 informations filed by the prosecutor in my case. These statements from the prosecutor are used to establish probable cause that I committed the crimes alleged in the informations. Without a plea agreement between me and the state, these statements should not be used to establish cause to believe I committed any of the crimes charged. Further affiant stayeth not. David Haig, subscribed and sworn to before me on the 6th day of May 2005. Irene Robinson, Notary Public and for State of Alaska. After I was convicted, I filed a complaint with the Alaska Bar Association of Scot leaders violating my right against self-incrimination and prosecuting me. This is Scot leaders' certified response to the Bar Association. It's to Mark Walber, Assistant Bar Counsel, Alaska Bar Association. RE Attorney Grievance, ABA file number 2007D173. Received October 2007, Alaska Bar Association, via U.S. mail. In this affidavit, Scot Leader says, Haig believes his statement given as part of plea negotiations was wrongly used against him. However, this was not the case. The state relied on information obtained from Zellers in prosecuting Haig. But as we already pointed out, he quotes my statement, not Zellers, to prosecute me. So, David S. Haig, summary of the statements 2 men filed on Haig called. It doesn't say Zellers or anybody. And in here it says the same thing. Haig stated Tony Lee pulled some of this. Doesn't say anything about Tony Zellers. So he lies about that here, and because it's in an affidavit, it's perjury. Then he says, again, the fact that Haig nor his attorneys have raised this issue in pre- or post-trial motions or appeals is indicative of the fact there was no violation. Any attempt to use Haig's plea negotiation statements would have resulted in a motion to suppress. That is proven false by these protests to Mr. Leaders. The filing of this motion by by Chuck Robinson, and then by my affidavit being sent to Scot Leaders in 3 different ways. By fax and by courier, and then by fax to the Alyeska Ski Resort Hotel where Scot Leaders was attending a district attorney conference. Okay, you can go back up there. These documents prove serious criminal conduct by government officials to cover up violations of basic constitutional rights. It is my belief that I was tased to prevent this evidence from being presented in a court of law. And I'd also like everyone to know Judge Margaret Murphy, in nearly 13 years, has still not ruled on Robinson's motion or my affidavit protesting the use of my statement against me. Thank you for watching.